Thank you. Council Bill 119368. So I wanted to just make some remarks. I would love to be able to sit up here and say that they are brief, but they will not be brief. So buckle up. So before becoming a council member, I was a civil rights attorney for 10 years. My law practice included many types of cases, but the foundation of my practice was representing people whose civil rights were violated by those in power, including by police officers. Many of my clients were monolingual Spanish speakers, women, or people of color. I had the honor to advocate for their civil rights as a constitutional lawyer in federal and county courtrooms across the state of Washington, including here in Seattle. But my advocacy for people's civil rights and my commitment to advocate for police reform extended well beyond the courtroom. For example, in 2008, I was appointed by then Mayor Greg Nichols to serve on a blue ribbon panel to recommend changes to the City of Seattle's police accountability system. After 8 months, the task force recommended almost 30 changes to the police accountability system, many of which needed to be negotiated with the city's police unions. Some of those changes were successfully negotiated while others were not. So I understand that disappointment that comes along with not getting everything you want in labor negotiations after advocating for them for so long. My work as a civil rights lawyer was fueled not just by my law degree, but by my lived experiences as a Mexican-American woman growing up in Central Washington as a migrant farm worker. I have unfortunately personally experienced what it means to not have public confidence in the police. And as recently as this past July, I witnessed one of my own brothers be pulled over and treated unfairly and disrespectfully by law enforcement in front of the house I grew up in. So for those people that are passing judgment on me for supporting this contract on the basis that I somehow don't get what is at stake here, let me disavow you of that belief. I do get it. Not because I have heard a recent story about police brutality, but because I've seen my own brothers and family members experience racial profiling and unconstitutional policing. I've sat in rooms with Black and brown families as well, with men who have been stripped of their dignity by a man wearing a police uniform. I've sat in a room holding a woman's hand while she sobbed and cried about being tased and physically assaulted by an officer and then being unfairly prosecuted for assaulting that same officer. I've sat in a room listening to a mom or grandmother telling the trauma of having lost her son or grandson after an encounter with an officer. I became a council member to put those lived experiences, my legal experience, and my subject matter expertise in the specific area of constitutional policing, police reform, and accountability to work. And I certainly did not sign up for this job to take a step backwards on police reform. That's why in 2017, I was honored to work with my friends on the Community Police Commission to chart a path forward on passing a belt and suspenders ordinance that would lay out our pie-in-the-sky vision for the police accountability system in Seattle. There is no question that our goals were lofty, and along the way, we each knew that many aspects of the accountability ordinance that so many of you have cited here in this room today would need to be negotiated in good faith with the Seattle Police Management Association and the Seattle Police Officers Guild. Indeed, that is why in section 3.29.510, the accountability ordinance, we laid out our collective understanding of how and when the accountability ordinance would or could be implemented into effective law. The language of the accountability ordinance clearly provides that the accountability ordinance is in limbo until two things occur. One, collective bargaining is completed, and two, the court overseeing the city's compliance with the consent decree reviews the collective bargaining agreement and the ordinance, all to determine compliance with the spirit of the consent decree. The accountability ordinance also clearly provided that until these two things occurred, quote, the current accountability system shall remain in place to the extent necessary to remain consistent with provisions of the consent decree in the matter of United States of America versus City of Seattle, close quote. Shortly after passage of the 2017 accountability ordinance, the city attorney's office filed our legislation with the federal court seeking approval of it and requesting permission to immediately implement the accountability ordinance. The court, in an order dated September 7, 2017, declined to approve the accountability ordinance, thereby consistent with the accountability ordinance, leaving the current accountability system in place. And in that September 7th, 2017 order, there were three different areas in that order in which the court not only invited, but in fact ordered the city to submit the accountability ordinance and the collective bargaining agreements at the end of the collective bargaining process to the court for judicial review. And I'm going to take a moment to read directly from the court's order. On page 3, lines 3 through 8, the court indicated that the court declines to rule on the entirety of the ordinance as it relates to the SPD accountability system at this time. Until the collective bargaining process is complete, the court cannot be assured that the ordinance as it stands today is a final product. The court declines to rule on a variant of the ordinance, but will await the final version that is ultimately implemented following collective bargaining. Also on page 3, lines 14 through 18, the court stated, the court simply declines to place its final imprimatur on what is essentially a work in progress. The court cautions the parties who either are or will be engaged in collective bargaining over provisions of the ordinance that the United States Constitution and the right of the city's citizens to have constitutional policing ultimately trumps all other concerns at issue here. And on the final pages, page 4, lines 8 through 11, the court conditionally approves the creation of the Office of Inspector General and also some of the provisions related to the Office of Police Accountability, but cautions that its approval is conditional and states, quote, if these provisions change in any way as a result of the collective bargaining process or otherwise, the parties, meaning the City of Seattle and the Department of Justice, must so inform the court and resubmit the provisions to the court for further review. On November 5th, 2018, Judge Robar held a status conference to learn more about the tentative agreement and the city's next steps. It was clear to me during that hearing that Judge Robar had some concerns that aligned with some, but perhaps not all, of the Community Police Commission's concerns. I also heard him state that he could not and would not weigh in on those concerns until this City Council voted to approve the tentative agreement. Colleagues, I would suggest that it is incumbent upon this City Council to now take that step to approve this contract and to petition the court to, with the city's guidance, evaluate whether the deal represented in this contract meets the mandates of constitutional policing. I believe that the city's best interest in our ongoing journey of reform is best served by pursuing a legally viable path through the judicial process. Some have argued that rejecting the accountability ordinance aspects in this contract and heading back to the negotiating table on those issues is the more viable option. Unfortunately, I disagree with that position. Rejecting this contract will send the parties back to their respective trenches, where each side will begin the process of orchestrating their legal positions in likely litigation that will consume whatever reservoir of good faith is left between the parties, and that is unacceptable. Again, I believe that it is now the City Council's turn to approve the tentative agreement, as we did last November with the Seattle Police Management Association. This is the next step in what has been a very long journey of progress towards the long-term and sustainable police reform accountability that we all seek. As one of the authors of the accountability ordinance, let me assure you that there is perhaps no one else on this dais that is more vested in protecting the integrity of the legislation that this City Council unanimously passed in May of 2017. Together with community partners and our former colleague, Tim Burgess, we clocked hundreds of hours and yes, in some cases, literally shed tears and sweat to craft this legislation. I care deeply about the accountability ordinance and about this city's ongoing and iterative work of constantly reforming the Seattle Police Department. The accountability ordinance, however, is not the Constitution of the United States of America. It is an important piece of legislation that aspires to meet the mandates of constitutional policing. It is also an important piece of legislation that, as I've previously discussed, the federal court has declined to approve until collective bargaining with our police unions is final. That moment has come. And on balance, I believe that the contract is a better deal for the city than the contract that expired on December 31st of 2014. And today is one of those days where I find myself in the unfortunate position of agreeing with some of the observations made by my friends at the CPC while disagreeing as to others and fundamentally disagreeing as to, one, the impact of this contract on our ongoing police reform efforts, and 2, the appropriate next steps to take to continue making progress on police reform. I believe that friends can remain friends even in the midst of disagreement on substantive issues. And just because I have come to a different conclusion than the Community Police Commission, that does not mean that I do not have profound respect for their work and role within our accountability system. And there have been many remarks made publicly and privately to me about the CPC that I find incredibly troubling. So let me be clear. I believe that the CPC is doing exactly what it should be doing. For those, it's not easy to lift up concerns that are not politically expedient. For those that question the CPC's legitimacy within our accountability system or the depth of their representation of community, I ask you to reevaluate your position. For years, communities that have been disproportionately impacted by unconstitutional or unlawful policing have not had a voice within the morass of government. And the CPC was specifically created by the consent decree to address and lift up those concerns of those community members. So accordingly, the CPC has taken its charge under the consent decree seriously, and we must continue to support the spirit of what CPC was designed to do. Second, I am recommending that my colleagues approve this tentative agreement for 3 basic reasons. 1, Chief Carmen Best, who's with us in chambers today, has clearly stated that approval of this contract is necessary to increasing department morale and to her basic ability to hire and retain additional officers. The contract brings the compensation we offer to our officers up to a competitive level with cities that we ordinarily compete with for recruits and lateral hires. Currently, Seattle is dead last in this wage comparison. This contract would bring Seattle officers' wages to the middle of the pack of the 7 comparative cities on the West Coast that historically have been used as a benchmark for compensation comparisons. Second, city-sanctioned public safety service continue to tell us time and time again that virtually every single neighborhood in the city of Seattle believes we need additional officers to effectively deal with neighborhood-specific public safety concerns. That is an important aspect of the evaluation for this city council in determining whether or not to approve this contract. While I am not satisfied with every term included in this contract does advance some critical reforms to our accountability system that we will lose for years if this contract is not advanced and reviewed by the judge overseeing our compliance with the consent decree. So I'm going to spend time on that last point. And while I don't have time to go through every single aspect of the contract that could fairly be characterized as progress, I do want to spend some time to highlight a few that are important to me. 1, I believe that this contract allows the city of Seattle to increase civilian oversight of the police department in order to strengthen public confidence in our police department. It does this in a few critical ways. It increases the number of civilians in the Office of Police Accountability, which investigates complaints of misconduct lodged against officers. Many have criticized that the civilianization of the Office of Police Accountability doesn't go far enough. But and they cite the accountability ordinance as requiring complete civilianization. But my reading of the accountability ordinance simply provides that there be a mix of civilian and sworn investigators, and this advances us in the direction of increasing the number of civilians within the Office of Police Accountability. Secondly, it legitimizes the entire existence of the Office of Inspector General as the 3rd leg of the city's accountability system with full and unfettered access to information from SPD and OPA. Let me say that again. This contract legitimizes the entire existence of the Office of Inspector General for Public Safety, which has the responsibility to do full system-wide audits of the Office of Police Accountability and the Seattle Police Department to ensure the health and the fidelity of our police reform efforts as it relates to the consent decree and the need to continue to engage in ongoing sustainable police reform. Without this contract, the Office of Inspector General effectively would sit on a shelf and have no power to do anything. Thirdly, This contract abolishes the Disciplinary Review Board, otherwise known as the DRB, as the third venue for officers to pursue appeals of disciplinary actions. In my experience, that is the area in which we saw many disciplinary proceedings be dismissed or be reversed in favor of police officers and in contravention to those filing complaints about discipline and about misconduct. In my view, abolishing the DRB goes a tremendous way towards increasing the public confidence in our disciplinary system at the Office of Police Accountability. And lastly, this contract would allow for full implementation of body-worn video cameras to be worn by all uniformed officers. Body-worn video cameras are seen as a tool for improving police services and public confidence, and I believe it is time for us to fully deploy that as a tool. So from my perspective, in this thing we call a negotiation, it is fair to say that there was an appropriate amount of give and take to balance the needs of bringing wages up to a fair and competitive level and cementing key aspects of the accountability ordinance. The question for us is whether we are willing to forego not just pieces of police reform, but all of it while we continue to wade through the legal battles that will ensue if we reject this contract. We cannot throw the baby out with the bathwater. We should not leave aspects of the accountability ordinance that are included in this contract on the table. We should take what we've been able to achieve and commit to continuing to work for more, both through the judicial review process and through the impending labor negotiations that are going to come to us very soon, and through the various reopeners that are included in this tentative agreement. This contract is not perfect, but it is progress, and it continues the reform process that we began in 2012. Our labor negotiation process on this contract in particular has been tough. It's been tough on us as management, it's been tough on community, and it has been tough on the men and women of the Seattle Police Department who have been working in 2018 under 2014 conditions. But ultimately, we have before us a contract that recognizes the collective bargaining rights of SPOG members under Washington state law, while also prioritizing the need to ensure that the public can continue to have confidence in our police officers. And I believe that rejecting this contract now would be a mistake. This being said, I believe that there are aspects of this contract that worry me. This is why I'm advancing a resolution that we will consider after this bill that would request that the city attorney's office petition the federal court to review the tentative agreement and the accountability ordinance, as he indicated he wanted to do at the recent status conference on November 5th, 2018, and in his September 7th, 2017 order, in which he declined to approve the accountability ordinance pending city council action on a contract with our police unions. I believe that that is the appropriate venue to address concerns about the standard of review when discipline is being appealed by officers, adjustments to the 180-day investigation rule, and the narrowing of the subpoena powers of the Office of Police Accountability and the Office of Inspector General as reflected in our original accountability ordinance. It will be up to the federal court overseeing the consent decree to pass judgment on those aspects of the contract and the accountability ordinance that bump into the consent decree and the Constitution. And colleagues, with all of that being said, I would urge you to join me in voting in favor of ratifying this contract and in saying yes to the resolution we will discuss shortly.